For Chapter 46, we are looking at gifted education and legal issues, procedures, and recent decisions. Ultimately, this chapter is going to inform us about various legal issues associated with gifted education, the steps that you would take if you had a legal issue associated with gifted education, and specific cases that have happened historically pertaining to this issue. So the most significant aspect of the legal framework in which gifted education operates is that unlike the statutory legal protection provided to the disabled student, there is no federal government mandate requiring school districts to provide special education for programs for gifted students. In other words, it varies state by state. So you'll see in this this map over here, state by state, what this means. In Georgia, it's green because gifted program is mandated and it's fully funded by the state of Georgia. What does this mean for lawmakers and the gifted student? It is up to the individual state. So that is why every state is a different color on that map. 3/5 of the state have passed a statutory mandate requiring special instruction for gifted students. So that is where you see the green and the purple on that map. The remaining states have opted for a permissive route, meaning that the school district may, but are not legally required to, provide programs for the gifted. And that's where the red states are on that map. Those red states leave a lot of room for error here, and it makes monitoring legal developments in gifted education super difficult in that because it's not mandated by the state, it's really hard to see the development and what's happening in those states. So once you have decided that you have a legal issue with whatever is happening in your gifted education experience, there's a ladder that you must climb. There's a super wide range of issues, and this 5-step ladder must be completed within your issue. So negotiation, mediation, due process, administrative review, and the courts. And we're going to go through and talk about each one. It's important to realize that as you work up the ladder, cost rises. So ideally, you would just stay in that number 1, negotiation. So to start, we're going to look at negotiation. I provided you this picture of the 4-step process: preparation, exchanging information, bargaining, and closing. Exchanging information is a super important piece because if you have an issue, you need to make sure that you have all the associated information, forms, documentation that you need. The bargaining is where you get what you want. That's where you're like, hey, this is my issue. What can I do to get you there? As a general rule, all complaints should begin at the source. So if you have an issue with the gifted testing coordinator, that's where you begin. If you can't get what you want through the gifted education coordinator, then you're looking at the placement director. Then you're looking at the principal. Then you're looking at the school board. The school board would be like the most extreme place for you to take it in terms of negotiation. However, within your district and all school systems, there is an approved board that you would take for your last step. The next piece is mediation. It is a process by which disputes are resolved in an informal manner with a minimum of time, money, and emotional and psychological stress. This is what you're going to do if negotiation doesn't work. Only 21 states have mediation available to resolve issues in gifted education, and below this is where I have broken down state by state within those 21 what it looks like. It only should be used if it cannot be resolved at the school board level. Due process is if mediation is not available or if an agreement cannot be reached. So if you are in one of those 21 states, you have mediation available. However, if you're in the remaining states, you don't have mediation available. So due process would be your second step. In order to go through due process, which is really just your legal rights owed to you by the people, you must call a meeting where you present the appropriate documentation and there's a hearing officer in place. The biggest difference between mediation and due process is the idea of the hearing officer. The hearing officer is going to be the person who makes the final decision. And so in that way, where negotiation gives you that back and forth, and mediation is like that middle ground where you may get a piece of what you want and they may get a piece of what they want. due process, you're putting all of your eggs in the basket of the hearing officer. The last or like most extreme piece that you could go to is to take your issue to court. If the appeal to the state agency is not satisfactory, the parent or the school district may decide to take the matter to state or federal courts. The chapter really wants you to understand that before you go to court, you need to understand the laws. So if your state does not legally make the district provide special education, then you can't take them to court because it's not part of the state law. You need to understand that the process will be expensive, timely, and emotional, that the process could be super lengthy, it could take years, and that you need to hire a lawyer, and that is where you're going to spend a ton of money. So when you're going through this process, there are 11 incredibly common legal issues presented within gifted education, and we're going to go through those. The first is early admission. This is when a parent wants to put their child in school before they are of age. So most states mandate that the cutoff is September 1st. It varies state to state, but across the board, it's most traditionally September 1st. So there's two cases, Doe versus Petal, Wright versus Ector. Doe versus Petal, a parent wants to put their child in at age 4. She has to be 6, but she has documentation that says she's physically, emotionally, and mentally ready. So the state says fine. Wright versus Ector, a parent enrolls a child in private school first. The private school has a different cutoff. Then they want to put them in public school. The mother tries twice unsuccessfully because the child is not of age and doesn't have any documentation that proves that they should be there. The next thing is provision of programs. This happens when a parent wants to get programming for gifted education. So unless the state mandates that school districts provide gifted education, these suits brought by parents will for the most part be unsuccessful. So if the state says no, you don't need to provide gifted education, then the parent's always going to lose because the state law is the higher authority. There's a big case in Bennett versus New Rochelle. This is basically 109 gifted students are identified. They only have funding for 37. So this parent sues the district when their child is not picked in a lottery. However, the wording in the law says that the district should develop programs to ensure that children reach their full academic potential. The use of the word should lets the school district get scot-free. The next thing is racial balance in gifted programs. We've talked about this a ton already in our class. Basically, this is what is happening when there is a higher percentage of a certain race in a gifted program versus others. So basically, the states and districts have gone through the ringer trying to avoid this at all costs. However, there's been 3 big cases, and ultimately they've just been desegregation suits. And as a result, states have changed their standards to try to avoid this happening. There's more information provided here about each one individually that you can look through. The next piece is Carnegie units. Over here, I provided what a Carnegie unit is. At the end of the day, this only happens when a student takes an advanced class before entering high school and they want to get credit for high school. However, they are still in middle school. 22 states are empowered to grant Carnegie units to students upon the successful completion of advanced courses prior to admission of high school. This is true in the state of Georgia. Another problem arises with transfer students. This is what happens when a child, when the needs of a gifted child are not met by the school or district that they're placed in. So if your child is gifted and the school that they're supposed to go to because of where they are geographically doesn't have those appropriate accommodations, then issues can arise in that transfer. Davis First Regional Board of School of Trustees, this family wanted to redo the district mapping. However, they were denied on that, but their child was gifted and was able to transfer schools. Another piece is appropriate instruction. As teachers, we can totally understand this. Basically, this tension arises because the school district has various pieces that need to be met by the teacher. However, the parents don't think that it's appropriate. This case listed below, you can read about it more, but ultimately this parent says that the student was identified as gifted. However, the school district didn't provide him the appropriate instruction, and that each person needs to have individualized instruction. So their needs need to be met. Gifted and disabled. This is what happens when a child is identified as both gifted and disabled. Ultimately, the result of both of these court cases is that the individual learning plan for the child needs to be met. So if the child has a learning disability, they're entitled to special education services and gifted education services. Transportation, this is the issue that arises, like if your child needs to get to a gifted education site and there's not transportation available, who's responsible? More times than not, the Department of Education is going to rule against the district and say that the district is responsible for transporting that child. Tort liability, this is accidents that happen within programs. So some residence programs, field trips. These are some kind of hard to read, difficult cases of basically children being harmed within the programs provided for gifted education. So where does that liability lie? Homeschooling occurs when parents are unhappy with education of their gifted student and they need an alternative route. There has not been a case that focuses on due process for a homeschooled child. However, I do think this is interesting to look at about the number of homeschooled students by state, this map over here. It's important to ask yourself various questions, and I've listed them here when you're considering gifted education and homeschooling, because are you doing your child a disservice by taking them out of the school where there is programs for them? And that is it. I will post the PowerPoint for you to look through because I know I was talking pretty quickly. So thank you. And let me know if you have any questions.